This is estate planning attorney Jason Lindamood, and today I want to talk about the difference between an executor and a successor trustee. Essentially, the difference is that they act under separate documents. Your last will and testament will appoint somebody to be your executor, which is a term that we've probably heard more than a few times, right? And this appointment is going to take place when you die. This is going to be the person that you're going to ask the court to appoint to make sure your wishes are complied with. If you have a trust, the successor trustee essentially serves a similar purpose in that it's going to be the person you've appointed to carry out everything as you've delineated in your trust. Similar roles, two different terms, controlled by two different documents. A couple of things to keep in mind regarding executor versus successor trustee that we sometimes don't necessarily think about. An executor can only be appointed when the will becomes operational, which is when the person dies. Now, let's contrast that to a successor trustee who can step into the shoes of the primary trustee even if the primary trustee is alive. For instance, think of a scenario where I create a trust and I am my own primary trustee, but let's say I have a bad day. I'm in a really bad car crash and I'm in the hospital and I'm incapacitated for a while. If you're my successor trustee, you can immediately step into my shoes and follow the terms of my trust even though I am still technically alive. And there's more to the story. And if I regain capacity, then I'll once again become my own primary trustee. And you'll go back into your role as a successor trustee. So they're interchangeable. That gives us some latitude in our estate planning, and it's a really big benefit to having a living trust, revocable living trust. Again, the roles are similar, but many clients are now wanting to pursue the path of a trust rather than a traditional will because of that very latitude and that malleability it has when life seems to happen and unforeseen circumstances decide to rear their ugly head. For trusts, no court orders are necessary, which is not an insignificant benefit when we're thinking about how, when, and to whom our property will be distributed and the expedience of the process. So a few things to think about. Executor versus successor trustee, last will and testament versus revocable trust. There's some benefits to either one. They are both really good foundations of our estate plan, and based on our particular sets of circumstances and our situation, one may be better than the other. Anyway, I think that's all I have for today. If this video was helpful and you're in a position to like, share, or leave a comment, that is always greatly appreciated. Talk to you next time.